All right, closed and executive session. This really should be the exception, not the rule. We find both new and experienced board members, I think, like to go into closed session probably more than they should. We say it's the most violated section of the Act, question mark. I think you can take away the question mark. Yeah. It's easily the most violated section. Either it's not done correctly or we're going into closed session for reasons that we shouldn't. There's only two reasons to go into closed session. And those are for the prevention of needless injury to the reputation of an individual, and if the person has not requested a public meeting. So the first part is needless injury. Just because you're going to talk in a negative way about somebody doesn't necessarily mean you have enough to go into closed session. It has to be significant enough to be needless injury. And the other part is, if you're going to talk about that person, you have to notify them, hey, we're going to talk about you, we're going to go into closed session. Do you have any objection to that, or are you asking us to do this in a public meeting? Well, every once in a while, somebody will say, yeah, if you're going to talk about me, you're going to do it in the open. You're not going to do this in closed session. You have to stay in open session, and your choice at that point either is to talk about it in open session or don't talk about it at all. An individual cannot be a board member. We got this recent decision from the Attorney General. We're not sure we agree with it completely, but it is what it is. The AG enforces the Open Meetings Act. We don't. And so they've made clear when we're talking about an injury to a reputation, we're not talking about a board member. So if we're going to say something negative about a board member, that's being done in open session. And then the second reason is if the closed session is clearly necessary for the protection of the public interest. So what's the public interest? Typically, what we're talking about is money, really pecuniary interest. So if you're negotiating a contract, and the amount of that contract, obviously you don't want to do that in open session and give away the farm to whoever you're going to contract with. Looks like we have a question. Clarifying abstention votes. Is it actually a no vote, or does it just reduce the total number of votes considered for a majority? This one's so easy, I'll let one of these two answer.
Oh, there is nothing in the open meeting statute that tells us what an abstention really is. Well, go ahead. This was your section. I'm sorry. I'll keep my mouth.
No, I think an abstention is a no vote to the extent that we're counting to the number that we need for any particular board action, right? So if you have a board meeting where you have all 6 members there, you need 4 votes to have a majority. If you have a board meeting where you have 5 members there, you need 3 votes to have a majority vote. Some certain sections of the statute require supermajority votes, right? For example, it must be 2/3 of the full board, right, of the number of seats on the board. So really, for most of your basic stuff, a no vote just means it's going to be harder to get to 4 if you have 6 members, or 3 if you have 5 or 4 members. So it technically counts as a no vote.
So if you have 6 board members, 3 vote yes, 2 vote no, 1 votes abstain, the motion fails,
right,
because it's not been passed by a majority of a quorum of the board.
So it's strange, but the number that you have there for the quorum, I think this was Lynn that had, the number you have for the quorum in that meeting could dictate the effect of that abstention vote, right? If one of those no votes doesn't show up for the meeting and you have a 3-1-1 vote, then I think that motion passes on a 5-member quorum. So it kind of is a no vote, it kind of is not, it depends.
You've answered her question. Okay. All right. Oh, and then the other thing about the public interest, it's not the board's interest unless they overlap. So we just like you can't go in for an individual board member, you can't go in for the board's interest. It's the public interest that we're looking at. So there are really only 6 reasons or 6 topics that are listed in the statute. Now it says in the statute, closed sessions may be held for, but shall not be limited to such reasons as, and they list the 6 reasons. If you're going to go with, but shall not be limited to, either be dead certain that it's lawful or talk to your lawyer, because we've had a lot of people that have gotten into trouble going into closed session for reasons that they shouldn't. So one, and this is one that schools actually use quite often, strategy sessions for collective bargaining, real estate purchases, pending litigation, or litigation which is imminent as evidenced by communications of a claim or threat of litigation to or by the public body. And we also say, it says reasons not limited to. This could be contracts, contract negotiations. This time of the year, we're getting a lot of calls about principal contracts, superintendent contracts. I think portions of that could be done. They're very similar to the collective bargaining, and we're talking about negotiating a contract. I think those are going to be close enough and would be allowed in closed session. Another reason, discussing regarding deployment of, or discussions regarding deployment of security personnel or devices. Unfortunately, we have that every once in a while now. We used to never have it. Investigative proceedings regarding the allegations of criminal misconduct. Every once in a while, we'll have one of those. Evaluation of job performance of a person. Nowhere in here does it say personnel. But every time you guys call us, oh, don't worry, Steve, we've got personnel on the agenda. Personnel is not a proper agenda item, and it sure in the heck is not a reason to go into closed session. So get that out of your heads. Everybody does it, but just because they do it doesn't mean it's right. So what it actually says is evaluation of the job performance of a person, but only when it's necessary to prevent needless injury to their reputation, and again, if that person has not requested a public meeting. So what the Attorney General has told us is you're going to have a discussion about somebody's performance. Let's say you're evaluating the superintendent, because I've had a couple just this spring where I learned after the fact that they were conducted 100% in closed session. That's not appropriate. We have AG decisions that tell us if you're talking positive things, that has to be done in open session. It's only when we need to prevent the needless injury to the superintendent's reputation and the superintendent says, yeah, closed session's okay, that you can actually go into closed session. So in the AG's world, you could go in and out of closed session. It's only when something comes up that's going to needlessly injure somebody's reputation that you actually go into closed session. So you can see how limited that is. It frustrates us. We know it frustrates you. You can't have an open and frank conversation to evaluate somebody. At least that's the feeling we get, or the feedback we get from boards. But that's the rule, and that's what we're stuck with. There's two other exceptions of the 6. They're never going to apply to us. They don't even matter. So you get one of the exceptions: you can't discuss appointment or election of a new member in closed session. That all has to be done in open session. I think we touched on this a little bit. Closed sessions are inappropriate because a matter might arise. So if something negative might come up, that's not a reason to be in closed session. You only go into closed session when it actually arises.
So they're laughing at me because there was a discussion at the beginning about how much I'd be able to keep my mouth shut, and they said I wouldn't be able to, and I can't. But one thing I do want to point out here, again, it may sound like I'm dogging on Spark, and I really like that software. We can log in and adjust agendas, and I love that software actually. But one of the things I don't like about Spark is that the default is to have a closed session, like an agenda item that's called closed session on every meeting. Closed session is not an agenda item. What you're talking about in closed session is the agenda item. And you shouldn't have a closed session on every agenda just in case we want to go into closed session, because that's not a way to get into closed session. So.
All right, we got a question from Alan. On a staff member who has been placed on paid leave, why can the staff know the name but the board cannot? I think the number one reason is the staff wouldn't ultimately sit to decide if that person's employment may be terminated at some point. Really, that's the thing. We're trying to keep the board from being biased, and the less they know, the better.
And a staff member has a need to know that there's going to be a sub in the room, or somebody needs to cover coaching or whatever. There's really no need to know for the board in the short term when someone's been put on leave.
That's just the Attorney General's opinions that tell us that. Other possible permissible reasons to go into closed session: we think receiving legal advice, it's not on the list, but clearly you have an attorney-client privilege. If you discuss that in open session, you lose that privilege. So we're very confident that that would be allowed to be done in closed session. Non-collective bargaining contract negotiations, we touched on that a little bit. Pretty much any contract, especially when you're talking about price, that can be done in closed session. Protecting student confidences, that could be a reason. We put but why, and the same thing for staff confidences. Our question would be, why are you talking about it, period?
Yeah.
Now, there are occasions where a student discipline matter gets appealed up to the school board. In that case, yeah, you'd be talking about it, and you might have some discussions in closed session. That would be appropriate. But short of that, you really shouldn't be discussing it. Same with staff confidences. If you're evaluating them, you're supposed to give them notice, and they get a chance to be present in open session if that's how they want it to go. Short of that, we like to keep, again, the board members in the dark. I know it's the only corporation in the world where we run it this way, but the reason is they have to be unbiased if they're ever going to make a decision on that person's employment. It makes us uncomfortable, not on the list. And that, I would say, probably half the time when we get calls, that's the real reason. It's not pleasant to do some of these things in open session. You don't want to, and we understand that. but that's not the law, and that's not one of the exceptions. Others, I'm sure as they come up, there can be other ones. Again, you look to see if they're similar to the ones that are on the list. We really don't have any court decisions or even any AG opinions or disposition letters that give us a whole lot of guidance on other topic areas.
And sometimes more than one might apply. So understand that sometimes combining two things together makes it so that the whole would be permissible.
All right, procedures. You have to take the vote to go into closed session while you're in open session. You have to record the entire motion. You have to record the vote of each member, and you have to put in the time when the closed session begins and ends. This was something they added in, and it trips people up still. If it passes, the president has to restate the limited subject matter for closed session and say that's all we're going to discuss in closed session. We hesitated to put this in. I hesitated to put this in. There is a court decision from the Nebraska Court of Appeals. It's now 20-some years old. What had happened in this case is they were talking about getting rid of the president, or the president was resigning. They then decided, hey, we need to have an interim. And so they discussed that in closed session, and then they came out and actually hired an interim. And somebody sued them and said that wasn't an appropriate, number one, it wasn't an appropriate agenda item. Two, it wasn't an appropriate closed session item. The Court of Appeals said, well, when you're talking about replacing a president, and you've got to have an interim, everybody knows that. Of course, you're going to talk about an incidental matter like that. This makes us nervous. I know the AG does not like this, and I raised it in a response to a complaint, and they really didn't like it. It's there. I'd rather use it as a defense than as an offensive way of operating. So it's there, but please be very, very careful if you're going to try to go down that road.
Well, and you'll notice that it said versus Board of Regents. The fact of the matter is there are special rules for the University of Nebraska system.
Not in writing, but just because UNL's special.
All right. Lynn wants to know, should the minutes reflect that restatement by the president?
Yes. We'll show you here in a second, Lynn. We've got a sample of one of our scripts, but yes, absolutely. Because how else do you know that it happened,
Yeah.
right?
You cannot take action in closed session. You have to reconvene in open session before taking any formal action. There's what formal action means. It's a collective decision or collective commitment or promise to make a certain decision or a certain action or making a certain policy. Formal action does not include negotiating guidance. This is probably the only exception given by members of the school board to either us as your lawyers or somebody else who's negotiating on your behalf, again, for contracts, collective bargaining, real estate purchases, things of that nature. So they'll go any, hey, we want to buy that real estate. Your range is 100,000 to 150,000. You don't have to come out in open session and announce that. Board members do have the right to challenge the continuation of closed session under two circumstances. One, if you think that they have exceeded the stated reason in the closed session motion, or if you think it's no longer clearly necessary either for the protection of the public interest or for the needless injury to an individual's reputation. It takes a majority vote of the members of the public body to overrule the challenge. Does the vote occur in or out of closed session? I think you have to come out of closed session and take that action because it says no action will be taken in closed session. The challenge and its results must be recorded in the minutes. We don't get this a whole lot.
Thank God.
But when we do, it's pretty contentious typically. Our recommendations, you've always done it that way. You got on the board, you're brand new, you're just doing it how they've always done it. Not the best way to do it. And I'd say, especially if you're new, go to these trainings, pay attention to the open meetings part. It's pretty simple once you've got it mastered, but there are some little quirks here and there. Use scripts when closed session is expected. It's very easy. We have scripts for pretty much anything that comes up. Here's an example for one of evaluating job performance and to get legal advice from your lawyer. There's the motion. You ask for a motion. It's moved and seconded. And then you can see there, after they go vote to go into closed session, you repeat this. And there it is. And we have, like I said, we have a variety of these for different things. We also have a checklist you can use for closed sessions.
And two real quick things. One, if you use Spark, we can go in and preload this. And number two, to Lynn's point, do you have to record the restated motion? If you have this script, you can just, somebody who has it can hand it right over to the secretary who's taking the minutes. And then they've actually got it to be able to type it all straight in there.
And finally, this came out of an attorney general's disposition letter. Essentially what they said is, in this case, was, hey, you called your lawyer and counted on them for their advice. And they took that into account when deciding, hey, are we going to push this on for any prosecution of any kind or do anything more drastic. And here, because they called the lawyer and had counted on the lawyer's advice, they kind of, I don't want to say they got a break, but they were given the benefit of the doubt in that situation. So if in doubt, call. You'll have that information and evidence available if anybody were to ever file a complaint.
We work really hard, all 5 of the attorneys at KSB, to be available, especially on board meeting nights. In fact, I don't know if you saw me quick texting. I had a board president text me as we were starting this webinar, and I just asked Cody to text the board president. It's our job to be available to you. A text that's going to cost, I mean, we do charge, but a text to us is going to be way cheaper in the moment than an open meetings complaint. So when in doubt, as a new board member, you can say, hey, Madam Board President, did you check with Bobby on that? Or is this something we should text about? I don't view that as, I mean, I think that's a cost savings thing for boards to do.